Thursday, July the 9th. We're picking up at the top of page 84, which appears to be a photograph of a newspaper titled the Deadwood Daily Pioneer Times. Black Hills, South Dakota, Saturday morning, March the 6th of 1920. Truth about Loudoun lowering taxes. William H. Malone gives Deadwood people truth. True and startling facts concerning taxation conditions in Illinois during the Loudoun regime disclosed in his speech. Ego characterized Malone's testimony about the South Dakota campaign as a dream. The above reproduction of a newspaper, one of many I have read, reveals that Malone's alleged dream was really Loudoun's nightmare. Chapter 10, The Accusers Accused. Following his conviction, William H. Malone delivered a speech before 2,000 or more of his hometown folk in Park Ridge, in which he denounced Ellis, Tuttle, and Huff because of the false testimony these corporation lawyers gave in his trial. We quote Malone as follows: "If these lawyers testified truthfully, they are bribers and should be prosecuted to the limit. If what they said is not true, they are guilty of perjury and should be prosecuted for that. Certain I am in that in either event they should not be allowed to practice law." Soon after that speech, the Chicago Bar Association filed charges against all three lawyers demanding their disbarment, and their cases were argued before the state Supreme Court. A study of the briefs filed by Ellis, Tuttle, and Huff in their own defense before that court, and a comparison of these briefs with their testimony at the Malone trial, throws a new light on this startling case. Had Malone possessed the facts brought out in the disbarment proceedings, and had they been presented in his defense, Ego's blatant and vitriolic persecution would have been wholly discredited. The Supreme Court, in its decision, said there was no proof that Malone had been bribed, but held the conduct upon the part of three lawyers warranted their suspension from the practice of law. Thus, the court agreed with Malone's declaration at the Park Ridge mass meeting. John W. Ellis. Let us now... Wait a minute. Let us now turn to the testimony of John W. Ellis as a witness. He was in a serious position. If he lied in the Malone trial, he was guilty of perjury. If he told the truth, he was guilty of splitting fees, which made him a subject of disbarment. Ellis' testimony referred to the years 1925, 26, and 27. He did not represent the Pullman Company after that date. The years named in the Malone indictment were 29 and 30. During these 2 years, Ellis had no dealings with the tax commission. Ellis, in his brief against disbarment, says, "He was before the grand jury 4 or 5 times, and preceding each, there would be a conference with Mr. Salter, Assistant U.S. District Attorney, and others, all trying to get him to say that he had paid the money to Malone." ABST 41, Record 224. Ellis said that an agent of the government called at his office, and he took a trip to Washington in connection with his own income tax. Ellis also testified under direct examination by the prosecution. "I said I never got anything before the tax commission I was not entitled to. I don't know that Mr. Malone got something he wasn't entitled to. I didn't give him $10,000. Ellis was asked by Malone's attorney if he told the grand jury the very last thing before leaving the room: "So help me God, I never paid a penny to William H. Malone." His answer was, "That is right." In the disbarment proceedings, the Chicago Bar Association charged that Ellis, as a witness to the government in its prosecution of Malone, testified that he received... At the top of page 87 is a penciled black and white diagram of what appears to be John W. Ellis. He's got a big old smile on his face, looks like a congenial man. The attorney for the Pullman Company is what it says underneath his name. The charge of obtaining favorable tax rulings from Malone and resulting tax reductions for the Pullman Company through the medium of campaign contributions is not established as evidence. Illinois Supreme Court in action to disbar Ellis. Going back to the statement on page 86, testified that he received from the Pullman Company a fee of $15,000 for legal services rendered in 1925 and a similar fee for services in 1926, and that from that fee he put $10,000 in an envelope and gave the envelope to a strange messenger whom he could neither identify nor describe. The first envelope he said he thought was delivered to Percy B. Coffin, the chairman of the Tax Commission, and the second envelope was delivered to another strange messenger upon the telephone request of Coffin. Ellis, in his brief, says the other $10,000 was handled in a slightly different manner than that previously. Coffin, not Malone, called me on the telephone and asked if I had the money, and I said that I did. And I said, "Shall I bring it over?" Coffin said, "No, I will send a messenger for it." Attorney Leviton, representing the Chicago Bar Association, portrayed Ellis as a schemer who had a transcript made in the proceedings in 1925 to hide his guilt, and therefore should not be believed and should be disbarred. Ellis, answering Leviton, said in his brief that he knew Malone was unfriendly to the Pullman Company, and on that account he, Ellis, made a transcript of the hearing before the State Tax Commission in 1925 to be available if he needed to contest the assessment in court. This transcript reveals that the hearing was before the entire board of state tax commissioners presided over by Malone, and all members took part in the discussion. Henry M. Ashton, assistant attorney for the Chicago Board of Education, and Miss Margaret Haley, represented the Chicago Teachers Federation, were present and took an active part in the proceedings. In addressing the commission, Mr. Ashton said that the tax dodging of the capital stock tax by large utility corporations worked a financial hardship upon the public school system, which was in great need of funds. At first, Ashton agreed with Miss Haley's contention that a higher valuation should be placed on the capital stock of the Pullman Company. However, Ashton later changed his mind following Ashton's statement. There appears this comment by Malone. "Well, Mr. Ashton, the chair is disappointed to say the least. I had pinned faith in getting assistance from you in the event the Pullman Company would appeal from whatever assessment this commission would make. I was a member of the commission that assessed the Pullman Company from which it appealed. I am still of the opinion that the assessment was legal and just. I do not propose to be obstinate enough to sit here and insist upon an assessment which on the face of it would mean more litigation. I do not mean that I am afraid of the Pullman Company, but I do feel now that we should try to agree upon an assessment which would be just to the taxpayers of Illinois and upon which the company would agree to pay." In support of his reason for having a transcript made, Ellis exhibits in his brief a previous suit to contest an assessment of the Pullman Company made by Malone in 1918. In that case, the Pullman Company appealed to the Superior Court of the Cook County, where on May the 16th, 1922, Judge Dennis E. Sullivan wiped out the entire tax of $659,144.57. This is one of the incidents that the attorney Ego told the jury that he knew never happened at all. Ellis says further, ABST 42 Record 225, that the government representatives said that they would refund his income tax on the excess of $10,000 for each year if he would say that Malone got the money, and he told them that he could not truthfully, that he would rather pay the tax, and he did. On page 90 is a photograph, black and white, of Judge Dennis E. Sullivan. And underneath it says the entire capital stock tax of the Pullman Company, amounting to $659,144.57 based on Malone's assessment, was wiped out in the Superior Court by Judge Sullivan on May 16th, 1922. Yeah, kind of weird. Judge Sullivan. We know another Judge Sullivan that's a very wicked guy in the Schaefer-Cox trial. All right, page 91. It is significant to note that the Supreme Court, in its findings against Ellis, said the charge of obtaining favorable tax rulings and resulting tax reductions for the Pullman Company through the medium of campaign contributions is not established as evidence. Frank L. Tuttle was taken before Judge Barnes, as were attorneys Blim, Huff, and Ellis. Afterwards, Tuttle changed his story and said that he had given money to a messenger that he thought took it to Malone to be used in political campaigns. Let Tuttle's brief in the proceedings to disbar him relate what took place. The record shows without contradiction that Judge Barnes, before whom the contempt matter was pending because Tuttle had not testified exactly as they had wished him to, said to Tuttle, "I have the highest regard and the highest respect for you. I don't want to send you to jail for contempt. My advice to you, not as a judge on the bench, but as a friend for many years, would be to consult a lawyer. He consulted his present counsel, and he told him he didn't feel he was in contempt. His lawyer told him, "It doesn't make any difference what your opinion about it is. You are headed for jail. My advice to you is to go over and talk in a friendly manner. My advice is that we go over and talk as man to man, brother lawyers, and see what they expect you to testify to." We took sweet counsel together, Psalms 1:14. We went, the then U.S. District Attorney and his assistant sat down with us and counseled together. At the trial of Malone, Tuttle testified he had sent money twice by a strange messenger he could not identify or even describe. The amount in 1928 was $13,000 and was for Governor Small's campaign. Said Tuttle, "I don't know that Mr. Malone ever did receive those contributions." Mr. Rathbun, counsel for Malone, questioned Tuttle as follows. I am reading from the minutes of the proceedings before the grand jury. Question: were you asked this question in that proceeding at that time? Did you split that $15,000 with anyone? And did you answer, "I did not"? Answer: yes, sir. Question: and were you asked this question by Mr. Salter or the U.S. Attorney present? Have you ever paid any money directly to or indirectly to William H. Malone? And did you answer to that question? No, sir. Not to my knowledge, not indirectly to my knowledge, and never directly. Answer: that is right. At the trial, Tuttle said, as to answering those questions on that subject, I was taken before a judge of the district several times for contempt order, and then I went back and testified again. My testimony as I gave it to the last occasion after I had been before a judge of the district was substantially the same as I have testified here today. When Mr. Ferguson of the Pullman Company gave me, Tuttle, the first check, he said, "Now, we don't care what you do with this money after you get it, but I want your assurance that this will be entered on your books as income and that you will return it to the government and pay your taxes. I want your personal assurance that you will handle it in that way." I paid tax on it, and the Pullman Company never reimbursed me for the tax I paid. On page 93 is a black and white drawing of Frank L. Tuttle, the tax attorney for the Pullman Company. Underneath it says, quote, "Eventually somebody came to my office and picked up the $13,000 of that money. I don't remember who that somebody was. I never got any receipt from the messenger, just delivered the envelope. Mr. Malone never told me he received it or didn't receive it. I never assumed it went to him. I didn't believe that it went to Malone. I never did believe it, Tuttle." Said Tuttle, ABST of record page 39, in disbarment proceedings. Listen, we're talking about lawyers here. There ain't no way that he's going to give a messenger $13,000 and not remember what he looked like or even remember who it was. That's ridiculous. Page 94. Eventually, somebody came to my office and picked up the $13,000 of that money. I don't remember who that somebody was. I never got any receipt from the messenger, just delivered the envelope. Mr. Malone never told me he received it or didn't receive it. I never assumed it went to Miss Him.
In that day and age, it would have been like 100,000.
Yeah, 13,000 would have been like 100,000. Yeah, I didn't believe that it went to Malone. I never did believe it. What weird, rambling statements to be used to convict a man and send him to prison! Exclamation point. After Malone demanded that these three attorneys be disbarred, Michael Ego supplied a certificate of character for Attorney Tuttle in the disbarment proceedings against him. He testified as follows. My name is Michael L. Ego. I am United States Attorney for the Northern District of Illinois. I am acquainted with the respondent, Frank L. Tuttle. I have known him, I guess, about 20 years. This is one lawyer speaking up for another, by the way. He appeared as a witness in the case of U.S. of America against William H. Malone. I called him as a witness for the government. I examined him and he testified. I would say that he was a very fair witness and he cooperated fully with the government throughout the case, and he testified, as I believed, to the truth. I had an office in the Chicago Title and Trust Building from 1910 to 1920, and I believe Tuttle was there practicing all of that time. I was acquainted with the reputation of his honesty and a fair dealing as a lawyer during the time I knew him, and that reputation was good. I vouched for his honesty and veracity as a witness, and he testified willingly. Tuttle consulted United States District Attorneys, as Judge Barnes commanded him to do, to see what he was expected to testify to by his brother lawyers, or face the alternative. Having performed, Ego certifies that Tuttle was a fair witness and he cooperated fully with the government throughout the case. He vouches for Tuttle's honesty and integrity. Judge Barnes held Tuttle in the highest regard and respect, but neither he nor Ego would believe him unless he would testify he had made donations to Malone. In suspending Tuttle from the practice of law, the Supreme Court of Illinois said, Tuttle's testimony shows that there was no substantial reduction in the assessment of the capital stock against these two companies as finally determined in the years he represented them under the assessments for previous years. Thomas D. Huff. District Attorney Michael Ego argued before the jury that Malone had accepted bribes from the lawyers representing the Chicago streetcar lines and the Pullman Company in exchange for reducing the assessed valuations of the capital stock of these corporations. Ego's theory in the prosecution was adopted by Charles Leviton, amicus curiae, in the disbarment proceedings, charging that respondents Huff and Cook participated in an arrangement whereby the Chicago streetcar lines obtained a substantial reduction in taxes. They, Huff and Cook, received substantial fees, and a member or members of said tax commission received from said Huff and Cook out of said alleged fees substantial donations claimed to be contributions to campaign funds. The Chicago streetcar lines must have been satisfied with the results obtained from the years 1927 to 1930 inclusive, or they would not have paid the firm of Huff and Cook the large fees the record shows were actually paid, said Leviton. Huff stated before the federal grand jury, which indicted Malone, and at his trial, that he made a campaign contribution of $10,000 to Malone when the latter was a candidate for governor, that the contribution was part of his fee from the Chicago streetcar lines. After receiving the fees, Huff, like Ellis, found himself in difficulties with the United States Internal Revenue Department on account of his income tax returns. In order to clear himself and to satisfy the revenue agents, he agreed to say that he had made campaign contributions to Malone. But the records show that this fee had been paid to the law firm of Huff and Cook for obtaining tax reductions by the order of the circuit court and not from Malone. Therefore, it is plain to see where the satisfying results referred to by Attorney Leviton were obtained. Huff, in his defense brief, states to the Illinois Supreme Court, I at no time stated or promised Malone that I would pay him any sum of money whatsoever in connection with the Chicago streetcar lines assessments. I never stated to Malone at any time that I would pay him, nor did I pay him any money for any favorable action on his part in the Illinois Tax Commission in connection with the streetcar lines capital stock assessment. I never agreed and never told him or said to him at any time that I would split fees with him or divide with him in any way the monies I received from the Chicago streetcar lines. Then, too, as a matter of fact, Malone never knew what I was to receive or what I did receive from the Chicago streetcar lines until I testified in the U.S. District Court. That is the first time he ever knew. Page 97 is a black and white drawing of Thomas D. Huff underneath, tax attorney for the streetcar companies, after Malone had been convicted on the theory that he had reduced the assessments of the traction companies. It was revealed that Huff obtained no reductions from Malone and had appealed to the circuit court to reduce the assessments placed by Malone. The circuit court wiped out capital stock taxes amounting to $2,384,316.50 without notice to Malone. The top of page 98. Prepare for a shock, but let the reader prepare for a shock. Huff now tells for the first time, ABST of record page 77 and 78, that he had appealed to the courts from the tax assessments which Malone had placed against the Chicago streetcar lines and had obtained reductions in taxes by court order, and that $225,000 was the fee paid his law firm for persuading the court to grant these reductions after Malone had refused. Judge wipes out $2,384,316.50 in taxes. The files of the tax cases referred to bear the titles People versus Calumet and South Chicago Railways Company, number B154865 Circuit Court, and People versus Chicago Railways Company, number B154866 Circuit Court. The assessed values for 1925 as confirmed by Malone were as follows. The Chicago City Railways Company. I'm not going to read the whole number. I'm just going to give you the rounded number. $3.9 million. The Calumet and South Chicago Company. $4.64 million. The Chicago Railways Company. $8.87 million. Total for all three companies, $17.4 million. The taxes on the three companies based upon these assessed values had not been paid for 1925 and 26, and the Calumet Company for the 1924 taxes were also due. The total amount which had accumulated and for which the suit was brought was $2.192 million. All the cases were consolidated and decided at the same time, December 19th, 1927. Judge Victor Arnold was the presiding judge. State's Attorney Robert E. Crow's assistant represented the people. The tax commission had no notice. If State's Attorney Crow put up a fight for the people to defend the assessment confirmed by Malone, he left no feathers. Top of page 99 is a photograph, black and white, of Judge Craig Alexander Hood. Underneath, the entire capital stock tax of the Chicago traction lines, aggregating $714,600, was canceled by Judge Hood in September 1932 after Malone had refused to reduce the assessments. The top of page 100. Left no feathers in the record. By court order, the taxes amounting to $2.192 million were cut to $1.181 million, thereby saving the Chicago streetcar lines $1.01 million, or 46.2% of the total taxes for those years. The file show the judgment was by agreement with the state's attorney. The Chicago streetcar lines again appealed to the Circuit Court of Cook County, protesting against the assessments levied by Malone. The case numbers are B253129, 3130, and 3131. The appeal was made in the 1930, the year in which Huff testified that he made the political campaign contributions to Malone. The appeal was heard by Judge Craig A. Hood, who, without notice to the tax commission, ordered the reduction in taxes of the Chicago Railways Company amounting to $303,000, in the Chicago City Railways Company, $152,000, of the Calumet and South Chicago Railways Company, $259,000. These reductions were the exact amount of the tax due on assessed valuations of the capital stock, which had been determined by Malone, and the amounted to $715,000. It was for this service that Huff and Cook received their huge fee. I'm just going to quickly inject my own commentary. A lot of times when it gives long numbers like that, like hundreds of thousands or millions, I'm rounding. I'm not going to say the whole number to the penny. Okay, it was for this service that Huff and Cook received their huge fee. These records also show that the judges to whom they appealed granted their request without publicity, but by agreement with the state's attorney. How anyone could believe that these lawyers gave money to the man who had refused to change these assessments is beyond the pale of reason. Homeowners cannot afford to hire lawyers. The reader must not assume that the sum of $2.4 million taken from the taxes of the Chicago Railways and the Pullman Company by the courts were the only capital stock reductions obtained by corporations on appeal. The court files contain records of many others. You know what? I'm going to go ahead and read to page 103. The small homeowner and the farmer who could not afford to hire attorneys to fight their tax bills were called upon to make the difference. We discovered the court records referred to too late to save a courageous public servant who became the target of a political persecution. As to bribery, Judge Hawley said the testimony given by Ellis, Tuttle, and Huff smacked of bribery. If we are to believe that bribery was committed, to whom would the Pullman Company and the Chicago streetcar lines pay a bribe? Would they bribe the man who had determined the value of the capital stock to be far in excess of that which the corporations were willing to pay? Would they bribe the same man for refusing to reduce those valuations? Or would the bribe be paid to the judges who, by their decisions, knocked off the total capital stock tax? If we are to believe that Malone was paid a bribe after assessing the Chicago streetcar lines capital stock and refusing to reduce the valuations on the plea of Huff, shall we assume a bribe was paid to Judge Arnold, who cut $1.01 million from the tax of that corporation? How much should we assume was paid to Judge Craig Hood, Again, by the same line of reasoning, should we assume that Judge Dennis Sullivan was paid a bribe? Malone was accused of receiving bribes, but the judges who actually made the reductions are now honored as jurists. The Supreme Court of Illinois, in the disbarment proceedings against Ellis, Tuttle, and Huff, the action which Malone had on many occasions publicly urged the court to take, declared there was no evidence in the Malone trial that he had accepted bribes. It was also found that none of the corporations these lawyers represented had received any favors from Malone. Peruse carefully the following chart taken from the official records. These figures show the capital stock assessments of the Chicago street car lines from 1926 to 36. Malone, as chairman of the tax commission, placed the assessments from 26 to 30, holding that they were just and equitable. When Malone had resigned, the Chicago street car line succeeded in obtaining satisfying results in terms of millions of dollars, as this chart so clearly shows. But the reductions were not obtained from Malone, but by Malone's successors in office. So what you have is a chart underneath that, and it says State Commission Net Assessments. Chicago Railways Company starts in year 1926 and counts upward. 4.5 million, 7.3 million, 4.5 million, 4.6 million, 4.5 million, 500, and then it jumps down after Malone leaves to 500,000, 500,000, 235,000, 220, 206, and 181. There's huge differences in the assessments once Malone leaves office. Top of page 103. The foregoing chart alone, casting aside all other elements, would startle any honest, intelligent mind, for it most graphically demonstrates that Malone was a real barrier in the path of the lawyers who represented the corporations mentioned. If these illuminating figures were printed in Braille, the blind would be appalled to find how far the income tax law has been prostituted as a means of purge and punishment since our esteemed blind Senator Shaw and Colonel Frank Knox so courageously denounced the un-American methods employed in its enforcement. And then on the top of page 104 is Colonel William Proctor. And underneath it says, multi-millionaire soap king who personally and financially backed General Leonard Wood for the presidency. He made a sporting proposition to William H. Malone and like a gentleman discharged his obligation by promptly making the gift as agreed. We'll pick up on the top of page 105 when we get ready to start again. Thank you for your time. My commentary after reading up to page 104 is that the judges and the lawyers and the tax officials is a den of vipers. And that if one man gets in there and tries to do honest things, they will turn on him and absolutely ruin him. So in order to be a part of the system, you have to be as corrupt as the rest of the den of vipers. But the truth about taxes is taxation is theft. And you can't have just and fair taxes because men's hearts get involved and it absolutely gets filled with corruption, graft, and greed. We'll pick up with page 105 when we continue. It's just like it always was. We know how bad it is today, and it was the same in 1920.